Hello, thank you for joining us today. My name is Lindsay Meyer, and I'm the Executive Director of the Higher Education Protection Network, which many call HepNet. We are here with a legal update. It's difficult with all that we do in our daily jobs to stay abreast of all of the updates in the legal world when it comes to youth protection. So HepNet offers an annual update on all of the case law and legal updates that are going on across the country and sometimes even the world. Thank you for joining us today. And with that, I give you Paul Bowman from Ideologic.
Hi, thank you, Lindsay. My name is Paul Bowman. I'm with Ideologic, and we are so grateful to have the opportunity to be part of the HepNet community as a sponsor with a shared goal of protecting minors. At Ideologic, we create custom software systems to solve important and complex processes, and we deliver it as an online service. We currently work with many wonderful organizations and institutions across the country, implementing youth safety and compliance systems that match their policies and help their youth programs stay compliant. Each of these institutions endeavors to protect minors on campus, and our software makes that easier for them. If you're looking for software solutions for your organization that will work with your unique processes, please visit our website at www.ideal-logic.com. And now I would like to introduce Anne Franke. Anne Franke provides consulting services to colleges and universities nationwide. She was instrumental in founding HepNet and served as the first board chair. Anne is a lawyer and has received many professional honors and awards. In addition to youth protection, her areas of expertise include governance, discrimination, investigations, and risk management. We welcome Anne today for her always popular annual legal update. Welcome, Anne.
Thank you so much, Paul, and thank you, Lindsay, also for getting started on our program today. I always enjoy pulling together the developments of the law in the past year that relate to child abuse in higher education. There are, of course, there's a huge realm of legal developments in the area of child abuse, and we look specifically at the subset of those that have connections to higher education. And under HepNet protocols, I'm giving a quick financial disclosure that mirrors what Paul just said as well. Through my firm, Wise Results, I provide consulting and investigative services to higher education institutions. Now, a great way to begin a presentation is with some enormous number or some startling fact to grab the audience's attention. So here I have $40.9 million. If we were all together in one room, I would ask for a show of hands whether anyone knew what that number represented. And Lindsay might raise her hand if she was keeping up with Ohio State's legal troubles. But that is the amount that the Ohio State University paid in compensation to 162 victims of Dr. Richard Strauss. Strauss was the team doctor for the hockey program, as well as other athletic and clinical responsibilities. He, now deceased, is credibly alleged to have abused minors and adults who were under his clinical care during their examinations. The most recent result, as you've seen, is this over $40 million outlay that the university has made to settle some, but not all, of the many lawsuits against it from the victims of Dr. Strauss. So now that I have your attention, I'll give you a brief overview of the session that we will, content we'll be going through today. As you can see, we have 3 major topics and then some bonus pointers at the end. We'll start with some developments in the courts and then move to the legislatures and developments in the executive agencies. Here and there throughout the presentation, I'll be making reference to the impact of the coronavirus on these legal issues. it's had this huge impact on all of us, on educational institutions, on law enforcement and the courts. So that provides sort of a backdrop to my presentation this year. And then at the end, I'll give you a couple of bonus pointers that are perhaps a little less legal, but things that you might enjoy and benefit from knowing about. So with no further ado, let's get started in the courts. The US court system, of course, is divided in several ways. We have criminal cases and we have civil cases. We have federal courts and we have state courts. And so I'm ranging across all of those different venues. And I'll also this year share a couple of international cases with you. At various points in my presentation, you'll hear a little bit of international news. I think more so than in prior years, child abuse and particularly images of child sexual exploitation are truly an international problem, as is child abuse itself. And so we have to place the United States in that world context. I'll also offer a reminder, at least one of the cases I'm talking about involves somebody who's been arrested, and that individual is entitled to the presumption of innocence until the court proceedings are concluded with a guilty verdict or until the individual pleads guilty. But in the early stages, we are obliged to presume the innocence of people who've been arrested or indicted. So I begin today with Professor Howard Joseph Borderbruga, and he was sentenced this spring to 11 years, almost 12 years in jail, in federal prison for possessing and distributing child pornography. Professor Borderbruga taught at Hillsborough Community College in Florida, and he was found in possession of more than 200 images and 47 videos depicting child sexual abuse, including videos known to have been produced in the Tampa Bay area. He also had on his devices conversations where he discussed a desire to sexually abuse children. I did not find allegations that his abuse occurred in connection with the community college, but he was active in the community and was very active online in collecting child abuse images. Needless to say, he was dismissed from his faculty position and is now beginning his 10-year or 11-year sentence. These are people who are in trusted positions and who exploit their positions of trust. I turn next to Officer David Delaney. Officer Delaney was a security officer at Red Rocks Community College in Colorado. So talk about a trusted position. Campus security are people we turn to when we have various kinds of problems. He was sentenced to 10 years in prison, and his collection of images included some of him with several children. The investigation and the judge concluded that he was grooming one of the children with whom he was pictured and was actually abusing another of the children with whom he was pictured. So during the sentencing, the judge concluded that he had engaged in a pattern of sexual abuse of children. So that was our campus public safety officer. I turn next to His notable development this year was that at age 80, he died while in prison, serving a 95-year sentence for child abuse and possessing images. He had taught mathematics at the University of Northern Iowa, and he also had chaired the faculty senate for a period of time. Again, an honorable person, a distinguished person on campus who was chairing the faculty senate. Again, his abuse was not immediately connected with his position at the University of Northern Iowa, and some of it occurred after he had retired. He was arrested at a rather advanced age, and I just dropped some of my notes here, but I think we'll be all right. He was arrested at an advanced age and, as I say, died of lung cancer while he was in prison. Now, I don't have a picture of Professor Michael Dorcas, but he is an expert in reptiles and notably snakes. On the cover of one of his books, A Guide to the Snakes of North Carolina, you see his name and a reference to Davidson College, where he was a biology professor. Now, he engaged in online conversations and gaming with children. He came to the attention of authorities in Wisconsin when a 14-year-old girl and her family went to the police saying that she had been chatting with him online and he enticed her to remove her shirt. She declined to remove her panties. This creeped her out, creeped her family out, and Wisconsin authorities traced her conversation partner back to Professor Dorcas's home. He claimed that he did not make use of campus computer equipment to engage in conversations with youth online. However, the college, to its credit, hired an investigative firm, assuming a forensic investigator, that did IT work on his computer at school and found that indeed he had engaged in many online chats with youth from his campus computer as well as from his place of residence. So he was sentenced in December to 10 years in prison. He had pleaded guilty about 11 months earlier. February, he pleaded guilty. December, he was sentenced to 10 months. Now, here is a more recent case, and this is someone who's been arrested and is facing trial. He helpfully wore a University of Missouri t-shirt for his mugshot, which indicates where he's from. This is 23-year-old Joseph Elledge, and his story is rather complicated, but also quite compelling, the allegations against him. He was married to a 28-year-old Chinese national who was also attending the University of Missouri as a graduate student. And he is now facing murder charges for the disappearance of his wife. Now, why does this relate to child abuse? Well, here's the nexus of the allegations. His wife became concerned that he had been spanking their one-year-old daughter to the point of leaving bruises on her. The wife took photographs of this and eventually, after quite a long period of time, shared them with another woman. Mr. Elledge told his wife that he would not do this ever again, and that deterred her from contacting police. However, the third party with whom she had shared the photographs did contact authorities. And shortly after that, Mr. Elledge noted or reported to police the disappearance of his wife. And based on various kinds of evidence, he was found to have visited some unfamiliar and remote parts of Missouri where it is believed that he disposed of his wife's body. There were certain suspicions, such as she didn't take her cell phone with her when she supposedly, by his account, left for a meeting with a friend and early in the morning. And the police were also suspicious because it took him 36 hours to report her disappearance while she was devoted to their one-year-old child. His trial has been delayed several times. He's had some Zoom hearings, and as best I can ascertain, the trial is yet to occur. His mother has filed for custody of the one-year-old child. So sometimes people are reluctant to report domestic abuse, are reluctant to report child abuse. There can be very rare and very unfortunate consequences. Safety plans for family members who have experienced or may experience abuse are a critical element in reporting to child hotlines and reporting to domestic violence abuse hotlines. So this is a case that perhaps we'll have some further news on next year. And that takes me now to several international cases. And again, noted faculty members. One case comes from Oxford University, where a theology professor who actually was a resident, resided in France, Jan Houston, as you see here, age 61. He was a very distinguished biblical scholar. I believe he specialized in the Old Testament. He was the editor of a journal. And he was found to have 28,000 images of child abuse on his electronic devices. He was investigated, and the criminal charges were brought in France, where he was sentenced to 1 year and a lifelong, I believe a lifelong requirement of registration and supervision. And in our second international case, we have a Northumbrian University composer, Augustin Fernandez, who was convicted in the UK of 13 counts, including, and my slide is slightly incomplete here, including sex with a young girl. I assume, from just reading between the lines here, connecting the dots, I assume that after he was found guilty, he was not immediately taken into custody, because the press reported that he fled and did not appear at his sentencing hearing, where he was ordered to prison for 23 years. So he is on the lam, on the loose, a distinguished composer. And in social media, he left a note, as you can see on the slide, reading, if that was a reprehensible act on my part, I have paid for it by falling on my sword, which to my mind suggests an implication of suicide, perhaps to take authorities down the wrong track in pursuing him. There was a similar, vaguely similar case in the US of a child abuser who fled before he was arrested, and he was on the FBI's 10 most wanted list, which was the first time, this was a few years ago, the first time that a child abuser was elevated to the status of the FBI's 10 most wanted. He was found in South America by an alert American citizen who had seen his face on the FBI's list. So I don't know how the authorities in the United Kingdom are searching for Professor Fernandez, but I bet they are on his trail. Now, that is a roundup of some of the many, many criminal cases. I found another criminal case that involved a university only insofar as a priest who was charged with abusing children claimed to be a professor. I didn't find evidence that he was a professor, but I think that claim of a faculty position was something he might have used to elevate his status with his potential victims. There have been lots and lots of cases to choose from. In HepNet, we provide a monthly update of news of child abuse, sexual abuse in higher education, and many of the cases involve abuse of children or the possession of abusive images of children. And so this is just a sampling to give you a sense of the kinds of positions of trust, the kinds of claims that people make. I also saw a report of a claim involving a teacher at a Jewish high school who sought out as victims children whose parents or grandparents suffered in the Holocaust. And part of child abuse is pledging the child to secrecy. And that teacher said, your family has already suffered enough from the Holocaust. Let's keep what's going on between us a secret. So this is the kind of manipulation that we see from child abusers. Having run through some criminal cases, I'd like to turn, now, and I forgot this one. Forgive me, this is a civil case. I'd like to turn to several civil cases. This is an Olympian, Conrad Mainwaring, who first came to my attention when he was arrested in Los Angeles. He was an Olympic hurdler and for many years has been a track and field coach in youth sports and in some university contexts as well. Now, the recent activity is that several lawsuits or several claims have been filed against Syracuse University, where Mainwaring was a resident advisor and I believe excelled in track and field and might have worked with youth in that context. I don't know that Syracuse claims precisely, but Syracuse University is facing a civil case that he allegedly abused students in the 1980s. Now, these claims are not stale because New York has extended the statute of limitations for child abuse claims. So we have a youth track coach and former Olympian. Who better to coach youth sports than someone with that degree of trust? Now, I'd like to just briefly go through what I'm calling here a geeky civil case. This is an employment law case over the obligations of a university to bargain with a faculty union. So the question in the case, as you see, was this: must a Pennsylvania public university engage in collective bargaining with its faculty union over background checks that the state legislature has mandated? We recall Sandusky committed crimes in Pennsylvania. The Pennsylvania legislature responded, among other ways, with a variety of new laws protecting children and requiring certain elements. And one was a requirement for background checks. So the Pennsylvania legislature passed a law saying faculty at the public universities, along with many, many, many other people, must undergo background checks. The faculty union in one of the university systems said that affects the terms and conditions of our employment. You, the university administration, need to bargain with us over the types of background checks and how they're conducted and the time frames, those sorts of things. The case went through the Pennsylvania courts. An intermediate appellate court agreed with the union, but in, I believe it was the spring, March, it was in March, the Pennsylvania Supreme Court ruled that the subject was not suitable for collective bargaining, that the university had inherent managerial authority to create this faculty background check program without the union's involvement. So the case is somewhat specialized in its application. There was a faculty union, there was a state legislative mandate for background checks. And so in other states where those two elements apply, this same issue might arise. Other state courts might decide it differently, but I think they would be looking to this Pennsylvania case as a kind of sister jurisdiction that thought through these issues and might have some rationale that a court in another state would consider and find persuasive. So as we wrap up things in the courts, let me just mention the effect of the COVID-19 outbreak in the US. Many courts have shut down, court personnel were working from home. They began holding certain kinds of low-level hearings by Zoom, certain meetings with counsel, but different jurisdictions are now very slowly considering how to reopen jury trials. And there, in the state courts, there is no uniform practice. How do you how do you select a jury? If you've ever done your share of jury duty, you may have sat in a room with 100 people and been called in panels of 30 or 50 into courtrooms to be vetted through the voir dire process for jury service. And then a jury sits in a box of with 6 or 12 or 13 people, depending on the jurisdiction, 14 people, and this is not social distancing. There are concerns. We have constitutional requirements for speedy criminal trials. So criminal trials are taking precedence over civil trials. There are arguments that it's difficult to evaluate credibility over Zoom. You don't know whether I'm wearing shoes or not at this particular moment, just to cite one small example. So the courts are in a chaotic situation, and there are people who predict that they will remain that way for a very long period of time. Again, with priority to criminal cases, but civil cases will be even further delayed. So that's a look back at the year in the courts. And now we're going to take a look at legislative developments. And there were surprisingly few this year, at least that came to my attention. So I've fit them all onto one slide, and let me just walk you through these. In the US Senate, there was a bipartisan group of 10 senators, eventually growing to 13 senators, who have introduced legislation to change the balance of privacy and transparency of our favorite online platforms, Zoom and Google, and want to ensure user privacy, and civil liberties groups say that this protects all of us so that Big Brother is not watching. On the other hand, these are platforms that are used for the creation and exchange of child exploitation images. So if you have what's called end-to-end encryption, then it's impossible to know exactly what is being exchanged. The big tech companies enjoy immunity from liability, from legal liability for the images that users post, create, post, distribute, share, sell. And this group of senators has sought to change that balance so that a company, a tech company, would be entitled to immunity only if it followed certain practices that allowed a bit of transparency into child abuse images, or took a bit of responsibility for the transmission of those images. This has been kind of a messaging bill. It hasn't really gone anywhere, that at least so far as I found. And so nada, we have a big nada on this. Now, another one that's related, and I should have put this on the slide, in the federal context, is that with the next stimulus bill, which may or may not happen, we've had a series of stimulus bills, and there are political fights over whether we should have another one. There are Republican views that hold sway in the Senate that colleges and universities and other employers should receive a kind of immunity for legal claims involving the transmission of COVID. And so the Republicans and the Democrats are at loggerheads on this, whether it would have an application to child abuse protection. It's pretty remote. It's much more about the transmission, but it is a federal immunity law that colleges and universities are very much in favor of. So moving on to the states, again, here we've had relatively little activity, perhaps because the country went into lockdown mode 3 months into the year. I did, however, notice 2 legislative proposals, neither of which has been enacted, that bear on child protection. In Michigan, there was a legislative proposal to create an overarching higher education ombuds office for the public universities. Michigan has been a site of several widespread sexual abuse tragedies in the higher education context. And so this was an effort to create another oversight body to which people could complain, bring concerns. Again, it's a proposal that has not been adopted. And second, in New York, Governor Cuomo advanced a proposal that was introduced in the legislature to require convicted sex offenders, registered sex offenders, to disclose all the screen names that they use if they're allowed access in the online world in general, to disclose all the usernames that they use to refer to themselves. So this was introduced in the New York legislature. It hasn't gone anywhere. New York already has a law that requires sex offenders to disclose their email addresses. This would take that one step further to their screen names as well. We are now moving into the executive agencies. Again, both, let me see if I have any state agencies. I don't think I do. I think we're talking about federal agencies here. And in particular, the United States Department of Education Office for Civil Rights. Back in May, OCR, as we call it, issued a huge rulemaking, final rulemaking on the enforcement of Title IX, setting out requirements that colleges and universities and public K through 12 school districts and a few private school districts would have to follow to deal with sex discrimination, sex harassment, and sexual assault. There were 1,000 pages of commentary, and there have been hundreds of hours of professional development seminars for Title IX coordinators and lawyers on the new regulations. The new regulations went into effect on August 14th. For our purposes, there is one element that can be important. The regulations created different internal procedures for colleges and universities to use versus K through 12 institutions. And that's all well and good. It's appropriate given the ages of college students and K through 12 students, or I should say the typical ages, because the lines get blurred. There are students who take college courses. There are prodigies who enroll in college. In Florida, the dual enrollment system can reach as young as 6th graders. So you may have 6th graders enrolled in college classes. If there were a sexual abuse allegation involving that child, and I'll use the term child because that's who it is, say the child is accused of having touched someone else inappropriately, there would be the college procedures at play rather than the university procedures. Or flip this my hypothetical around, say a college student inappropriately touched the 11, 12, 13-year-old who was sitting next to them in class. So these are gray areas that the regulations do not clearly address. Now, we may never delve into the gray areas under the current regulations. Candidate Joe Biden, Democratic nominee for our president, has indicated that he withdraws these regulations. He considers them to be too favorable to the respondents and not sufficiently survivor-oriented. And there are also several lawsuits pending against these regulations and the way they were adopted and implemented by the government. So if Biden wins the election, then it's a reasonable guess that these regulations will be thrown out the window and replaced with something else. And we may or may not end up with this fuzzy dividing line between claims involving children and claims involving traditionally aged enrolled college students. And the other development from the Office for Civil Rights in the Department of Education came from an investigative report that the OCR conducted of Penn State University. Again, the Jerry Sandusky's institution. And in March, the OCR, the Education Department, published 2 companion reports on the university's compliance with Title IX and also with the Clery Act. And in the Title IX report, you see this finding that the athletic department staff delayed 3 months in reporting an allegation against a youth camp coach internally to the Title IX coordinator. So this one has quite an easy lesson. Train everybody, all faculty, staff, the athletic department, just top to bottom, the president, the chaplains, to notify the Title IX coordinator promptly when they get wind of any issues involving sex discrimination. I would also add other forms of discrimination as well. Those should be reported to the university internal EEO office. And then we turn finally to the U.S. Department of Justice. And this is quite interesting. I had not really been aware of this at the time, but back in March, our Justice Department collaborated with four other countries, excuse me, in a group called the Five Eyes. And the Five Eyes are countries that share intelligence information to some degree with one another. And the countries are, in addition to the US, Australia, Canada, New Zealand, and the United Kingdom. And so the Five Eyes developed a set of 11 voluntary principles in collaboration with 6 international high-tech companies. And these are voluntary principles, and the 6 companies have agreed to follow them. And I give you one example here. This is principle number 9, that the companies seek to take an informed global approach to combating online child sexual exploitation and abuse, and to take into account the evolving threat landscape as part of their design and development processes. So it doesn't have teeth, but it is a shared commitment among Five Eyes countries and at least a half a dozen tech companies, with one hopes more to be added. The Department of Justice also this year proposed some regulations on sex offender registration and notification, but those aren't sort of immediately granular in the higher education context. So if you're a geek on sex offender registration, take a look at the regulations that I think were proposed in March. Now I'm coming to the end here. I'm just going to take a look to my left as I bring you a couple of bonus pointers. I know this is what you've all been waiting for, and I just put my notes down so we can extemporize a little bit here. You might have read in the news about QAnon. It's a far-right group labeled as by the FBI as a it's been on the fringes, and there's some observers who see it creeping into the mainstream. This is one of the QAnon big treatises, and this very morning on Amazon it was 5,000th in the bestsellers of books, and you see it ranked very highly in these other categories, in the top 50 in some specialized nonfiction categories. And out of almost 2,000 customer reviews, it has gotten 4.5 stars. So the buyers are not just people who are critical of QAnon, otherwise they would not have rated the book so highly. Now, why is this relevant to child abuse? Well, part of the QAnon conspiracy theory is that President Trump is waging a secret war against an elite and powerful group of pedophiles. And there are allegations of people eating children. You might remember 4 years ago an allegation that a pizza parlor in Washington, D.C. was the site of a secret pedophile ring, and someone went in there with a gun to liberate the children. Well, that was all hokum. And why this is relevant to higher education is that there have been some links between QAnon supporters and kidnapping of children. A non-custodial parent who is a believer in these theories of this vast conspiracy of people wishing to harm children, that non-custodial parent may seek to kidnap his or her children to protect them from this scourge. And so there have been some kidnapping claims in a couple of states. I offer this to you here simply as a bonus pointer, because if there is QAnon activity, if there may be QAnon supporters in your states, your child programming pickup procedures when we resume to more in-person youth programming may want to double check the validity of people who are there to pick up children, because I see the possibility of an increased risk of a non-custodial parent seeking to kidnap a child. That has always been a risk, and indeed it has been not only a risk but a problem. I think the risk is somewhat heightened now because of these conspiratorial theories that are circulating. And then finally, in my legal update, I wanted to bring you some good news. I've spoken in the past about a prescription drug called Diastat, which is used with children to bring to an end certain types of cluster seizures. So if an epileptic child is having a cluster seizure, Diastat can be administered. It sounds like an EpiPen or a similar kind of emergency use medication. The challenge, though, in youth programming is that Diastat is rectally administered. And so universities have faced the possibility and the reality of having children enrolled in youth programming who are epileptic, who have Diastat applicators that may need to be used on a child during certain kinds of cluster seizures. So a couple of years ago, I had some HepNet members come to me and say, we had a child with that issue and that medication. I was so glad that you told us about it last year in your legal update. So that really warmed my heart. Thank you, whoever. Thank you to our HepNet colleagues. Well, there is now a nasally administered alternative. Thank goodness we have Nasolam that has come on the market in the last year. I don't know if the prescribing protocols are exactly the same as Diastat, but if you're involved in running youth programming or making accommodations for disabilities, and a family comes with a Diastat prescription, you can just ask, have you talked to the pediatrician about Nasolam, and there may be an alternative that's much easier for youth programming staff to manage safely. So I want to end with a reminder to those of you who may not be in the know that we have the HepNet annual conference coming up October 12th to 15th. Like most programming, we're a virtual conference this year, and if you haven't registered, if you're not watching this video as part of the conference, and it's before October 12th, I encourage you to look into our program. We have some fabulous keynote speakers. We have some networking opportunities, great sessions. Our program committee has been hard at work for months, sifting through proposals and putting together just a wonderful conference. And one ever popular session during the conference is the Stump the Lawyers panel. So while we can't engage today with any Q&A, I'll be moderating the Stump the Lawyers panel with two very experienced university counsel. And so among the three of us, we'll be ready to answer any questions that you might have from this presentation, from other sources, from life in general. And so please use that session as a follow-on to this one if you would like. And our registration fee is $125 for HepNet members and $225 for non-members. You see on this slide our website, higheredprotection.org. So with that, I'd like to thank you for coming virtually today, for listening through this entire session. And it's been my pleasure, as always, to put it together for you. So Lindsay, let me turn things over to you for some final thoughts.
Thank you, Anne. I always appreciate this session because there's so much we do in our daily lives, whether it's at work or at home, or that grayness of both lives right now meshing together. But this presentation always saves me a lot of time in having to go out and do that legwork on the legal updates. So thank you for your wealth of knowledge. We always appreciate it. And thank you all for attending this session. If this is intriguing to you, or if you want to know more about these things, HepNet is a membership association, so you can join as a member. You don't have to be in higher education. Higher education has reduced rates, but anyone who supports our mission can become a member. And we have regular education just like this that occurs for our members. And as Anne mentioned, we also have an annual conference. So you may be viewing this after our annual conference has taken place, but we do have that every year around October. And some of our sessions are so popular that we always have them, like the legal updates, Stump the Lawyer, and then we have other sessions that come and go in and out, and some long-standing ones. So thank you all for attending, and thank you for all of the work that you do to protect youth and other vulnerable populations. We've got to stay together and try to do what we can do together. So thank you.